Hello class, this is for my summer 2019 class. Got two sections here for the full semester. Recording Chapter 5, Civil Rights. This will be for our third week of the class. Will be for the fifth quiz that you have, and will be the last of the chapters that we have for our first exam. So certainly focus on this and start to work on those test questions that will be used as your essay portion of the exams. And those questions will be on, three of those questions will be on your test. So certainly use that in your preparation. Here we are with Chapter 5, Civil Rights. And we had just finished Chapter 4, dealing with the rights of the individual. Here we're looking at rights among groups. And all of us in this class we belong to particular groups, different backgrounds in our lives. And as a result, we would hope that those groups would have some form of equality. And so when we talk about equal rights, then the question becomes, what is equal? To what degree should equality be promoted? And in large part, this has to do with the Supreme Court. Supreme Court ultimately has to make those decisions in the interpretation of the law, and to see if, in fact, someone's 14th Amendment rights, in particular the 14th Amendment that you'll read about throughout this chapter, is the one that determines, in fact, if people have had those rights violated and therefore are not being equally treated. And so that becomes the basis of the courts to make that interpretation. So we've seen recently the courts have ruled that there's suitable amount of equality to the point where there's not a need to continue to enforce the Voting Rights Act. You'll read about the Voting Rights Act on pages 175 to 177, and believing then that the Voting Rights Act is not necessary to have the federal government review the changes in election laws in particular states. These are states that have had evidence of discrimination in the past. Now, with that said, we can also see that gerrymandering, and certainly read about that in this chapter and in some other places in your text, has not been supported by the courts as well. So some areas there on the question of what is discrimination and how should it be ended, and what role is the state involved in ending discrimination. So we've seen statements made by the current Chief Justice of the United States Supreme Court, Chief Justice John Roberts, that we're in a post-racial society. And therefore, if people are not thinking about race, we don't need to have a government involvement to try to end any type of discrimination involving race, or less involvement, certainly. Now, you can make your own interpretation of that, and you can also make your own analysis on whether or not that's accurate from your own life and from what you've read and maybe the experiences that you've gotten on your own, or experiences that you know about from other people, and determine on your own if what Justice Roberts is talking about is indeed that accurate. So in part of it, it's brought about that we've elected an African American to be president, so therefore perhaps we are not really in a society that determines actions by race, so therefore we're a post-racial society. That's one of the claims made by, again, Justice Roberts, Chief Justice Roberts. But there are some counterpoints to that claim for sure, and this is a bit dated, as we can see there. And the sources are some sources that I've suggested, at least one of them that you can use for your news reviews. But when it comes to interactions with the police, the outcomes are not necessarily always the same for people based on race or economics. There can be other factors certainly to take into consideration. But we do see some differences there, some fairly consistent differences. And we do see still income inequality, where income inequality is at its greatest, which is not exactly clarified from the explanations here on the map, but that is the point, that there is an even greater amount of income inequality in the darker colors of this particular map. And you can find two areas in the Southwest and in the Southeast in particular where you see those greatest amounts of income inequality. And that's where you have a Latino population, an American Indian population, also in the areas of the Dakotas. And then you also have a large African American population in the southeast part of the United States. And so there you can see where you have a pretty strong correlation to a greater gap of income inequality and a large African American population. So Frederick Douglass, who was born into slavery and became a writer and a political activist during the Civil War era, strongly argued that it's an ongoing struggle, to try to make progress in our society, even to this day, that we still see this struggle that takes place. And so some of the counter argument to the idea that we are in a post-racial society, and even something like slavery, which we may at first believe has been resolved, it's still in existence too. It's now underground and perhaps even more vicious than ever before. And so here you can see a quote that's 9 years old, but unfortunately still relevant, from Time magazine. So read that over and think about that for a moment, that we still see that slavery is an issue in our society and in the world today. It's been an ongoing struggle. It's been a struggle for other groups in our society as well. American Indians, citizens in 1924. So not even 100 years as of yet have we seen that American Indians have been U.S. citizens. This is moving up to the 100th anniversary of when women were first given that right to vote. And questions still for other groups in society on what is equality, what rights should be provided to others. And your text does a very good job of pointing out the other groups and how they should be represented. The basis of a large part of the civil rights question comes from the Civil War, and in particular 3 amendments known as the Civil War Amendments. You'll be able to read about this on page 163 to 164. You can see that these 3 amendments suggest a considerable change in society if these are going to be enacted and enforced. Your text also indicates that there was a pushback or backlash to the Civil War amendments. Things such as Jim Crow, in which by a state-by-state issue or basis would determine how to enforce those Civil War amendments and to perhaps create an area of approved or legal segregation. And you would have towns that would perhaps say, would not allow for whites and blacks to be in that town after dark. And so that's where you get the term sundown towns. Whole book written about it, as we can see here. And I'll open up here for an opportunity for some independent research. And if you would like, you can look this over. And there'll be a there'll be a folder on the Dropbox online for you to submit your entry of evidence. As you can see here, you need a photo, find a city ordinance that would indicate that there is the town was in fact a sundown town, and you can earn up to 20 points bonus with that. So here's where we can see the basis of a large part of the pushback to the Civil War amendments, the de jure segregation by law, the basis of this court case, Plessy v. Ferguson in 1896, dealing with where people could sit on railroad cars. And some other forms of that backlash, that only whites could vote in a party's primary. And so therefore, if you only had one party that was dominant in a particular area, then that would be the one party that would be able to select the elected officials. And also making it a burden to even qualify to vote by having to pass a literacy test or having to pay a tax to go vote. So we can imagine that all of this would serve its purpose and diminish the overall voting turnout. There were interest groups, and this will be in Chapter 11. We'll go into more detail about interest groups, but there were interest groups that tried to counteract the pushback and to ensure that the Civil War amendments would be enforced and followed. And these are a couple of the groups that we can see there. And so in part to look at the 14th Amendment and to now include that to involve women as well along with men, and to ensure then that women would have rights, and one of those rights would then be elevated to the point of the right to vote and have its own amendment with the 19th Amendment. So in the process of ending segregation, a lot of that started after World War II. This was the president after World War II, during the last few months of the war, and then immediately after 1946, Harry Truman, the president, started the first Civil Rights Commission, and to look at ways then of ensuring protections and extending rights to other groups in society. And one of the major court cases that dealt with segregation in public schools was Brown versus Board of Education. And this came out a few years after the war in the 1950s. And you can read about that, as you can see there, several pages in your text. And it's very much worth looking into. Major change in our society. Again, wasn't easy. It's not as if everyone went along with these changes. And we can see that desegregation in schools created a considerable amount of conflict and issues in many states. And so what indeed was extremely important to bring about integration and really start to have a legal basis of desegregation was the Civil Rights Act of 1964. And there you can see the pages that go into considerable detail about the major segments of the Civil Rights Act. So here we can see what were some of the key points made from the Civil Rights Act, especially the one of 1964. Ending discrimination in public accommodations, discrimination in schools, and then have a consistent type of voter registration process for all people. Now this is a key case, but it's not really emphasized in your text. And the Heart of Atlanta Motel was a a motel that challenged the constitutionality of the Civil Rights Act was brought to the Supreme Court. The Supreme Court ruled that the Interstate Commerce Clause gave Congress the power to enforce the Civil Rights Act. And looking at the practices of society during that time, it clearly created discriminatory practices for people who were trying to compete in business. And based on the color of one's skin, they would not have the same opportunity to be able to compete and not stay in the same motels, have access to the same speed of transportation, restaurants, all those kinds of places and activities that we generally expect today. We can also see here the expansion of rights for women, and that certainly is emphasized there in your text. And one of the parts of looking at, in particular, women's rights is to look at the differences between the intermediate test and the strict intermediate scrutiny test and the strict scrutiny test. In large part, that difference is between the genders and the races and ethnicities. So it's an intermediate burden of proof, and the whole basis of this is, are there times in which there's acceptable forms of discrimination? And so could there possibly be an acceptable form of discrimination against women in which the government would need to review those particular practices? And there may be very rarely an opportunity in which there's an acceptable form of discrimination for a race or ethnicity, against a race or ethnicity. But perhaps an intermediate scrutiny test could involve a physical fitness test, such as a firefighter's test, in which the individuals trying to pass that test must prove that they have a certain amount of upper body strength. And if an individual did not have that upper body strength, and that may be primarily women that would fall into that category, but is the need to have firefighters with these physical capabilities more important than the basis of protecting rights for a gender? In large part, the courts then have ruled for the legitimacy of the firefighter test. Now, there's also unofficial segregation, in which there's no laws that create this segregation, but you do see in particular communities that some people are having more opportunities, better benefits than others. And it does seem to continue to break down based on ethnic separation or racial segregation. So then the question is, how did that happen and how can it be ended? So busing has been one of the ways of trying to end these differences within school districts in one particular community. And if you have schools in which some people going to these schools the majority of people are of one particular race and they get better benefits, should there then be state involvement to try to end that unofficial segregation? It's been violently received, as this photograph on your left suggests, and that has in fact been the case. It becomes pretty emotional, the idea that children would be bused considerable distance away from their homes to try to resolve these economic differences, these fiduciary differences, right? The differences in terms of the budget. And so perhaps busing is the answer, but it's not been very well received in many cases. And maybe there's other ways of trying to resolve these economic differences. And we can see here, as your text does go into detail, that the expansion of civil rights may go beyond than just race or ethnicity and gender and start to look at things such as age. Is there, again, a suitable time to have discrimination? And so that's the issue of ageism. Can there be a time in which the state does have a right to enforce particular laws, or a business does, for the sake of its business and for the sake of its customers, to diminish the rights of other people? And we'll come back to that issue, but we can see here on the issue of extending civil rights, some other groups that are involved in this. Some very important court cases. We can really see with chapters 4 and this chapter, chapter 5, that there's a great deal of involvement by the courts. And the outcomes of these court cases have impacted our interpretation of civil rights. So look over those pages and these court cases involving Latino Americans, Asian Americans, Native Americans, and disabled Americans. And so on the issue of age and potential ageism, is it a suitable form of discrimination to have a mandatory retirement age? And this may vary from one place to the next, or one company to the next, or one organization. But some rough requirements of age that we can see here in different organizations. And if in order to accomplish the task, the courts may then say in that particular area of employment, having a mandatory retirement age is a suitable form of discrimination. And that may not only be against people based on old age, but on young age as well. We can see forms of discrimination. And we can also see the expansion of equal protection for people for same-sex couples, as we can read here on page 192 and 193. The courts have ruled against a state, in this case it was Texas, to have laws that would prohibit sexual acts between same-sex couples, but allow those same sexual acts with heterosexual couples. So here we see the question of determining who should be admitted into college, and we know that this can be a very important issue, and who receives a scholarship or who just is admitted into a prestigious school. And so it can become a very important issue. And should that admission process consider someone's ethnic background? So this particular case looked at the discrimination, or what was referred to as reverse discrimination, when quota systems were in place and individuals, in this case Alan Bakke, as a white male, was now discriminated against, that he was not admitted because the quota for the number of white males had already been achieved. And that was viewed to be discriminatory, to have a quota system and limit the number of individuals of one particular background to be able to apply. The court did rule, and of course this is a very old case as we can see here, but the court did rule that racial consideration was reasonable, to at least consider that, to consider one's racial background, but should not then in that process discriminate against others by having a quota system. And that's been an issue now in the 2000s, so in the last 10, 15 years, still considering it, in this case, in Michigan law school. So both of these cases are referred to as Michigan cases, the Michigan cases. So you can see the importance of promoting diversity, but should diversity be emphasized to the point of creating a reverse discrimination, or another form of discrimination by now discriminating against white males generally is the group that they're considering. But it could be that you have just an overabundance of one particular group of people, and in that situation to promote diversity should there be just a reduction of that group of people. So I bring that up because we're seeing some cases that will probably be reviewed this summer involving Asian Americans, where there's in some colleges a very large percentage of people that are admitted that are of an Asian background, and attempts have been made in an unofficial way to reduce the number of Asian applicants or Asian admittance. And in that process, it appears to be, at least the complaint is, that that's another form of discrimination. So how do you promote diversity and then also ensure that everyone who's most qualified gets in? Perhaps that's seeking a balance that so far has been hard to achieve. And so we're left then with this ongoing question that we can see the difference there in these last two chapters. Chapter 4, focusing on the rights of the individual, and Chapter 5, looking at the rights of groups. And not always easy to find what is the best way to promote and protect those rights of groups. All right, so that's Chapter 5, looking at civil liberties. Our next chapter will focus on public opinion.